bailiffs have towed your car away for an unpaid debt. This video shows you ways to reclaim your car, and if the car is damaged while in the bailiff's possession, we show how to recover damages from the council or creditor, whom the bailiff is acting for. Your misfortune could be turned into a fortune, at the bailiff's expense. Your car is gone, and the police told you a bailiff company has taken it, and when you call the number the police have given you, you find out that bailiffs removed it for an unpaid debt. The debt is usually a parking ticket or traffic contravention debt. And having a car taken by surprise means that the owner of the car has no previous knowledge of the liability. You need to get your car back. And you need to understand the tricks and scams bailiff companies and vehicle compound staff deploy on you. Recording the call on your mobile phone, call the bailiff company and tell them that you want to pay the debt and get your car back. If the bailiff company gets awkward with you, let them. You can give your voice recording in evidence later. Next, send the bailiff company an email, asking for a copy of the bailiff's bodycam video recordings. Make a screenshot of the sent email to the bailiff company to record the time the email was sent. This will either get a copy of the recording showing the condition of your car when the bailiff took it. If your car was damaged while in the bailiff's possession, then it will not appear in the bailiff's body-worn camera recordings. If the bailiff does not provide you a copy of his video recordings, or it has been lost, destroyed or deleted, then the bailiff company cannot rely on their recordings if you later decide to bring a claim for damage to your car. If the bailiff cannot show the damage is not attributed to them, and it was pre-existing, then without the bailiff's body-worn camera recordings, the bailiff has no defense, and he will be liable for the cost of the repairs. If the bailiff suddenly makes the bodycam recordings reappear, after you file a claim, then the debtor can sue the bailiff company for a breach of the General Data Protection Rule, Article 15, and recover damages for that breach under Article 82. When the bailiff company agrees to let you pay the debt and collect your car, you need to prepare to attend the bailiff's vehicle pound. If you have an injunction or court order requiring a bailiff to return your car, then they must deliver the car to you. If you are paying a debt to reclaim your car, then you need to follow these simple steps. Pay with a credit or debit card. Your rights are better protected. If the bailiff or staff at the pound demands you pay in cash, which they often do, then offer to pay by bank transfer. Never in cash banknotes. You can then show evidence of the flow of money from your bank account, if you need to give it in evidence later when you make a claim. Bring someone with you, as a witness. The bailiff, of staff at the vehicle pound, might not let your witness onto the premises, but have them record a video, anyway. You can use it in evidence. Bring pen and paper, a mobile phone, and a selfie stick. You must write down anything that is said to you, and their name. Do not leave this to memory. You cannot rely on memory when making a witness statement into court. Ask the bailiff company, by email, to give you a statement of account. This is a document that explains how much the debt amounts to, an explanation of the bailiff's fees and disbursements in connection with taking your car. You can use this later. If you have been charged storage fees for your car that is more than £12 a day, or have been charged VAT, you may apply to the court to examine whether the fees and charges are actual and reasonable according to a set of rules. This is called a detailed assessment hearing under Civil Procedure Rule 84.16. It is best prepared by a solicitor, because, if the court finds that the bailiff's fees and charges are not actual and reasonable, then the solicitor can recover their costs from the creditor, or counsel whom the bailiff was acting for, and the creditor or counsel may recover them from the bailiff company's public liability insurance policy. All bailiff companies must lodge a public liability insurance policy with the council, or authority, before it can be allowed to undertake enforcement action on its behalf. The law says that when the debtor has paid the debt, the enforcement power ceases to be exercisable. Which means the bailiff or the vehicle pound can no longer hold your car. This is because Provision 6.3 of Schedule 12 of the Tribunals, Courts and Enforcement Act 2007 says,
"The property in all goods ceases to be bound when the amount outstanding is paid."
That means the car is no longer bound under the enforcement power, and it now belongs to the debtor or owner, once again. Never sign a document a bailiff or compound staff presents you. The document might be asking you to waive your rights to recover damages should your car be damaged. Take a photograph of the document using your phone, and if you are forced to sign it as a condition of getting your car back, then you may apply to the court for an injunction and apply to the court to order the bailiff to deliver your car back to you. The law is Section 3 of the Torts, Interference with Goods, Act, 1977, which says,
"Form of judgment where goods are detained. In proceedings for wrongful interference against a person who is in possession or in control of the goods, relief may be given in accordance with this section, so far as appropriate." The relief is an order for delivery of the goods, and for payment of any consequential damages, or an order for delivery of the goods, but giving the defendant the alternative of paying damages by reference to the value of the goods, together in either alternative with payment of any consequential damages.
That means you can also recover damages if the bailiff or vehicle compound staff continue to hold your car after you have paid the amount outstanding. And bailiffs cannot use your car as a lien to force you to waive your statutory rights. So, if you are compelled to sign a document against your wishes, you can simply add a squiggle on the document and add the words, "Signed under duress." That might not void the contract, but it shows the court that your car was illegally detained, after you paid the amount outstanding, to pressure you into signing a contract that you would not otherwise agree to. Take a photograph of the document before you hand it back. You need to give a copy of the document as an exhibit, if you decide to bring a claim. When you have paid, you will be taken to your car. Never give the bailiff, or compound staff, the keys to your car. Before driving away, take detailed photographs of any damage to the paintwork and exterior body panels, and be sure that no external parts, such as door mirrors and wipers, have been removed. Using your phone and the selfie stick, take a video of the underbody of your car. It is common for vehicle pounds to move cars around by lifting the car off its wheels using a forklift. Check for evidence of tampering with the vehicle locks and its tracking system to see whether it is still transmitting its location on a map. If your car is fairly new, check under the bonnet, and see that the engine or the gearbox has not been swapped out for an older one. Check your belongings that were in the car before it was taken. Note down anything that is missing. It is not uncommon for compound staff to break open the glove box and steal items inside. Also, check that the spare wheel and toolkit are still present. If there is any damage or missing items, report it to staff before you leave, and be sure to record this on video using your phone. You will need to make a witness statement when you make a claim later. When you drive the car away, check the operation of the steering, gears, or transmission, and the brakes. Be sure the car is operating as it should. If it is not, then stop driving. Send an email to the bailiff company, and report a description of the faults and missing parts. Then make a screenshot of the sent email on your phone to record the time you gave the email. You will need to give this in evidence in your claim. If your car is unsafe to drive, call a recovery service. You can reclaim the cost of the recovery service later, so keep all receipts. When you have got your car home, you must give the creditor or counsel, whom the bailiff was acting for, a reasonable opportunity to come and inspect the damage to your car. Always copy in the bailiff company, and mark their copy with the words, "For information only." You cannot start a claim for damages until you have done this. If the creditor does not respond to your opportunity to come and inspect your car, then you can send your car away to be repaired. When you have the bill for the repairs or replacement parts, you may write to the creditor or counsel again, with a simple letter of claim. Set out in your claim a history of the enforcement, the amount of your losses you are claiming, why you are claiming them, give your bank account details in the letter, so they can settle your claim, and of course, set a deadline for them to pay. If the creditor or counsel does not pay, then you can start a claim by making an application under Civil Procedure Rule 84.13. If you are not the debtor, then you can make a Part 7 money claim. The law is Provision 35 of Schedule 12 of the Tribunals, Courts and Enforcement Act 2007, which says,
Care of goods removed. An enforcement agent must take reasonable care of controlled goods that he removes from the premises or highway where he finds them. He must comply with any provision of regulations about their care while they remain controlled.
Regulation 34 of the Taking Control of Goods Regulations, 2013, further says,
Care of controlled goods. Where the enforcement agent removes controlled goods, other than securities, from premises or a highway where the enforcement agent has found them, the enforcement agent must keep the controlled goods, so long as they remain in the enforcement agent's control, in a similar condition to that in which the enforcement agent found them immediately prior to taking control of them.
And, subparagraph C, says,
The storage must be secure and the conditions of that storage such as to prevent damage to or deterioration of the goods for so long as they remain in the enforcement agent's control.
That establishes that the bailiff is liable for the care of your car after he has taken it. However, the creditor or the counsel, whom the bailiff was acting for, is also liable. Provision 66 of Schedule 12 of the Tribunals, Courts and Enforcement Act 2007 says,
This paragraph applies where an enforcement agent breaches a provision of this schedule. The court may order the enforcement agent, or a related party, to pay damages in respect of loss suffered by the debtor as a result of the breach. A related party is the creditor.
That means, the debtor can bring the claim against the creditor. In this case, it's usually the counsel or authority the bailiff was acting for. Your damages also include the number of days you have been deprived of your car while it is in for repairs, often at £35 a day. Dealing with bailiffs can help you with making an application and a claim for damages. We have experienced solicitors who know enforcement regulations and the procedures to achieve a successful outcome in the shortest possible time. In many cases, it won't cost you anything, because solicitors can recover their costs from the other side. We hope you have learned something new today, and remember, if in doubt, keep 'em out.